congratulate every single member of the committee. Every single member was reelected. It's been a terrific committee all week. Every single member was elected, not without challenge in a few cases, I'm told, but everybody was reelected and comes back, so everybody's familiar with the issues and the discussion of what's already been done, et cetera, et cetera. We're going to go into public testimony immediately, and Secretary of the Republican Party of Texas, Mr. Virgil Cruz, has a submission that he received in the allotted time frame that he wants to present formally. So, Virgil, yeah, up at the front mic, I think would be good.
Thank you, Mr. Chair. I promise I won't talk as long as the last time I was at this mic, and I promise that I have less of a stack for you than I did for platform. So, pursuant to Republican Party of Texas Rule 32B, as permanent convention secretary, I am causing automatically and without debate the following resolution, singular, to be referred to this committee on behalf of the delegate who submitted it. It was submitted not later than 30 minutes prior to the first meetings of the permanent committees starting. So here we go, one piece of paper. Thank you, Mr. Chair.
Thank you. And next we will have a roll call of the members present. So probably use one of those.
All right, here we go. Christian Bentley. Okay, Randy Dunning.
Yo.
Mac Duncan.
Here.
John Boucher. Here. Dwayne Wright.
Here.
Keith Nelson.
Here.
Russell Rush. Here. Ken Leonard. Here. Mike Schneider. Here. Susan Valiant. Here. Dave Wilson. Here. Ronnie Jones. Here. Rachel Hooper. Eric Opiella. Here. Josh Flynn. Here. Nate Joy. Here. Caleb Piato. Sandra Kind. Here. And David Westbrook. Chuck Burnett. Here. Kathy Hager. Here. Leslie Thomas. Here. Rick Cook. Here. Bruce Campbell. Here. Naomi Nerbez. Justin Nichols. Here. Susan Guggenheim. Present. Tim Lambert. Here. Brooks Coleman. Here. Mark Russell. Here. And Brandon Hodges. Here.
Okay, thank you, Mike. We'll go straight into public testimony. We'll take testimony from the front. If we can kind of follow the same procedure that worked well during the week, we'll call off the first 3 or so, and if you'll come up to the mic, and every time somebody's coming up to the mic, we'll call out who the next one would be. What is different on this night is that we only have 2 minutes per testifier in order to testify. My intent is to go at least 1 hour on public testimony unless we run out of delegates that wish to testify. And whether we go any longer than that, that'll be at the discretion of the chair. So, Mike, you want to start calling the delegates up?
It'll be a long night. Levi Ryder, SD 28, Jackie Walken, and Shannon Greer. Oh, okay.
Mr. Chairman, I think Levi.
No, up here in the front. And if you know anybody that that has left the room to go next door, either next door, you know, and they've been called, go ahead and let them know, text them, whatever, so they can get back in the room. We're not striking them off just because they didn't show up at the right time.
My name is Shannon. I don't know how this works. I'm a first-year precinct chair, just finished my first year. I'm here to ask you to reconsider 8N because we've had a county chair that when I walked into this, I was very excited to be a precinct chair, and I walked out of it completely stunned at how a county chair ran an organization. It's appalling. And for anyone who has common sense and business acumen, it was disturbing. He didn't hold meetings, he attacked people, he didn't respond to emails, he didn't respond to phone calls. And I'm surprised I signed up for a second year, but I did. So I'm hoping that you guys reconsider 8N, because I think that we need to hold our elected officials accountable for their behavior and how they act and how they treat people.
Jackie walk in, or Levi Ryder here? Paul Sullivan, Jenny Lyncher, and Cindy Crow.
My name is Jackie Waken. I am a precinct chair in precinct 2080. I live in Frisco. And I take my job as a precinct chair very, very seriously. I witnessed in the past 2 years a county chair that failed to schedule meetings for a year and a half. We did not have meetings. Many times we were at a meeting, they would call to order, they'd kick us all out. He didn't like something, so the meeting ended. We never had any more meetings at all. Please reconsider 8N. We lived this nightmare. He destroyed the Denton GOP. We need help, and we need to hold these people accountable. Thank you.
Can you repeat what county, did you say what county you are in?
Denton County.
Denton
I'm a
County.
precinct chair in 2080, and I witnessed this the whole time. And I take my job seriously. It was disgusting. He's horrible. Please reconsider 8N. We need it. Denton County. We don't have a GOP right now. He has destroyed it. We have to start from scratch.
I was going to say,
What in
point
particular?
of inquiry. Susan Valiant, SD10. Is there a proposal on what changes? I mean, right, but I mean, they're saying
I
what's
was
wrong, but is there
David Westbrook, SD19. What about 8N in particular are you
8N.
wanting addressed?
Levi? Levi in here? Okay, Paul Sullivan, Jenny Lyncher, and Cindy Crow.
Good afternoon, Paul Sullivan from SD 13. I'm here really just to talk about the proposed Rule 44, specifically not the entire rule, but the applicability to judges and judicial candidates. The reason why I would encourage the committee to reconsider relating to judicial candidates is for two reasons. The first is that it will put judges in a very uncomfortable situation in which they are applying the law. Judges are supposed to apply the law from the legislature, which then might get them sanctioned as a result of the censure. We do want the judges to use discretion with what they can, but there will be situations in which the legislation hasn't got around to it yet. It would be nice if we could get all of the things that we put into our legislative priorities actually into law, but there might be a gap between the time in which we have our convention here and then when it's applied. So we want to make sure that the judges aren't put in that very uncomfortable position in which they're doing their job appropriately. We don't want them not applying the law. So that's the first reason. The second reason is that there are circumstances in which you can recuse a judge. If they cannot be impartial and unbiased, then you can recuse them. If they have signed saying that they have to follow the platform, which is not the law, you will get them recused. And there are scenarios in which judges can use their discretion, and we want them to use their discretion in line with our principles. We will not have those judges. We will only have Democratic judges using principles that are not our principles, using their discretion, and all the Republican judges will be excluded. They won't be able to make those decisions. So the reason why I want to exclude judges from 44 is to allow them to still use their discretion without being excluded, and to make it so that they can do their job, which is apply the law. I know Republicans talk all the time about judges legislating from the bench, but we need to have them apply the law.
Thanks, Paul.
Mr. Chairman.
Okay, Jenny and Cindy?
Question?
Okay.
When a candidate runs for a position, a judicial position, and runs as a Republican, Mac Duncan, SD3, I'm sorry, and runs as a Republican, is that candidate, by running as a Republican, already affirming positions in the Republican platform? And if so, why would they not be recused at that point? I'm not a lawyer, so I don't understand the difference there. They're already running as Republicans, so if you could address that.
So there's a lot of case law out there relating to what are the basis for recusal. Party affiliation is not considered a basis for recusal. So no, according to the case law, no. I worry that if we did make them sign this, then it might become a reason.
Okay, if I may follow up. Yeah,
Sorry about that.
Tall people have to lift the mic a little bit. If they're already running as a Republican, then what is that's what I'm trying to say is, what is the difference? They're running as a representative of this party. I don't see any substantial difference there for them to acknowledge their belief in the principles. So help me to understand that if you can.
So judges are allowed to use certain discretion.
Right.
If they're a Republican, they likely have Republican values. If they're a Christian, they're likely to have Christian values. Those aren't, according to case law, it's not a reason to exclude them. However, if we make them sign that they are going to follow the current platform, that might be a basis for recusal. In addition to that, there are, if there is something that is currently on legislation being talked about, that is a basis for recusal, that they can't talk about that. Like, there are certain situations in which you are directly relating to something that's up for election, that's about to be changing the law. That judge can't talk about it. That judge can't be the judge to make the decision relating to the applicability of the law. That's really what I'm concerned about, which the basis of the platform will make it so you can't talk about anything on the platform.
Right.
Thank you for testifying tonight.
And I'm sorry if I'm not as clear as I should be.
No, you're doing great. I have a question. In your opinion, why would a judge or any judicial candidate run as a Republican?
They would run as a Republican because they have Republican values.
Do you think, in your opinion, would it be because they want the support of Republican voters?
They want support of Republican voters and financing potential.
Okay. So when a Republican judicial candidate runs for office, how do they campaign to get Republicans to vote for them?
They have a lot of limitations about what they can talk about, but they can.
So what can they talk about? Can you give us an example in a judicial race? You know, I'm not grilling him. I'm asking him his opinion on question. I'm sorry if it feels like I'm grilling you.
Yeah, let's not get into debating the testifiers at this point. We can open that back up.
Okay.
Later,
Thank you
though.
for your testimony.
Okay, SD 17, Jenny Lyncher, SD 17, Cindy Crowell, SD 17, Fred Shukall.
My name is Jenny Limcher, and I'm from SD 17. We were told during our SD 17 caucus meeting today by the Rules Committee member from SD 17 that some language was taken out of rule number 46, closed primaries, and the language that was taken out was concerning to us, which I'll read to you in just a moment, but we would like to add it back and keep the changes as well. So it says here, rule number 46, closed primaries, in primary elections and primary runoff elections conducted by the Republican Party of Texas, only, and before it said citizens of the United States, and then they changed it to registered voters of Texas, is what we were told. Only registered voters of Texas who qualify to vote as Republicans in accordance with this rule may cast ballots in those elections. My request would be just to put back citizens of the United States and keep who are registered voters of Texas.
Mr. Chair, that was my amendment. I totally agree with you, totally.
Okay. Yay. Thank you very much.
Thanks, Jenny.
Steal y'all's thunder, but you're right.
Okay.
She's 17. Point of information, she's 17.
SD 17. SD 17, Cindy Craw. Right? That's okay.
Okay, hello. Well, I was going to come up here and speak about rule number 46 as well, but we got an explanation. But I do want to say that there was a big ruckus in our caucus, SD 17, when we heard that. You should have seen the uproar. And so I'm really glad that the word citizen is still going to stay in there and nothing's going to be changed, because that's the way most of the voters and most of the Republicans, if not all, that I've talked to, want it to be that way. So thank you so much for your time. She stole my thunder, so I can't tell you what else I was going to say. Thank you, guys.
Thank you, but I would remind the delegates that just because some favorable comment is made in response to a delegate, that does not mean it actually changes yet. That we'll take up that debate afterward. Yeah, you got a few seconds left.
Okay, if for some reason the word citizen is removed, I would suggest stating that you must show proof of citizenship by either your birth certificate or a U.S. passport, and that's all I have to say. Thank you. Because if citizen comes out of there, why are we even talking about election integrity? Think about it, people.
Okay, SD 17, Fred Schuchel, and Sophia McFridge.
Chairman, members of the committee, thank you very much. My name is Fred Schuchard, and I am a four-time judicial candidate. Kristen, to address your question, it's very simple. When I ran on the platform, I will enforce the law. I'll actually show up at the court. I'll rule on motions. That's the difference with judicial candidates. We can make broad statements. We can't give any indication of how we're going to rule on any specific issue. And requiring us to certify the platform does exactly that. And if you censor us for our rulings because we followed the law, then we might as well be Democrat judges. And the problem is, and the speaker before me said it perfectly, we'll all be disqualified, so you'll have the idiot Democrat judges, the rogue judges that you are trying to stop making all the rulings. And we just can't have that. In Harris County in 2016, we had a complete slate of judges. In 2018, we had a half slate. In 2020, we had a half slate. 2022, we were able to fill it again. In 2024, we have less than a half a slate. And my serious concern is if these rules don't have the judicial exemption in them, Rules 43 and 44, we're going to have no slate. Because I can lose my bar license. I can get punished by the state bar by violating the judicial canon. And we don't want that. We want good Republican judges on the bench. And if a judge can't tell you I'm going to follow the law, he's a Democrat. If he tells you I'm not going to rule fairly and timely, they're a Democrat. And that's how I went to Republican voters. These people don't follow the law, I will follow the law.
I appreciate you addressing that question. And I just want to ask you one question. I promise not to grill.
I'm a lawyer. Give me a microphone to speak. You can ask as many as you want.
So our principles, I think, are broader. Our principles are broader. In your opinion, would speaking to principles be allowed when you're campaigning?
you'd have to, and I hate to be a lawyer to you, you'd have to define what principle means. Following the law is a principle we can talk about. There's a separation of powers. I can't talk about what I want the legislature to do as a judicial candidate. I can't talk about what I want the governor to do as a judicial candidate. And that's the bind that the legislature and the executive branches in Texas don't have that we have.
Are you allowed to talk about Second Amendment rights, for example?
No, because if I ever get that question coming to my court, the first thing that the ACLU is going to do, they're going to look at our website, they're going to see I committed to this platform, and then they're going to recuse me. And we don't want that, because then we got the people deciding the issues we don't want deciding those issues.
Yes, Ronnie, and remember, we're not debating, we're asking questions.
Ronnie Jones, SD12. Over here.
Oh, sorry about that. I saw the gentleman behind you with the...
So you spoke about how your bar license could be in jeopardy. What's the difference between a judge's license being in jeopardy and a state legislator's license being on jeopardy if it's an attorney running for state legislator under our principles and platforms as a Republican?
Because as a legislature, he's not acting as an attorney and not acting as an officer of the court. So he can actually technically get, he or she can get sanctioned for that, but that's not going to happen. If I'm sitting on the bench, I'm a sitting duck for that. Yes, sir.
Yes, sir. Brandon Hodges from Senate District 31. I just wanted to ask as an example, I sat on this committee Tuesday, and I was trying to do some regular work, and I get an email from work, and we had been given a subpoena for a court case. And I'm giving this example just to see, because I want to know some info on this.
Just remember, the advice is worth what you paid for it.
Exactly. Company A is suing Company B for some oil wells. We're not in the lawsuit. We're subpoenaed because we have information on the well bores. Well, so what I'm worried about with this judicial, not exempting judicial, is if I was a lawyer, it doesn't matter if you're plaintiff or defendant, a process or a strategy would be to find a public record that this judge is a Republican and is signed or given an oath affirmation that they belong to the Republican Party, and part of that platform, priorities, or planks is their pro-fossil fuels and pro-energy independence. Couldn't this put us in a situation to where that case somebody's going to ask or move or push or cost me money as a business owner to keep that judge from being recused so they can replace him with a judge that may not have as much objectivity or discernment in that case?
You hit the nail on the head.
Fred, don't answer that. I'm going to rule that's debating and arguing the point, but yeah.
Just remember, he was going to get free advice.
He's just trying to get free advice.
Exactly.
Yeah, that doesn't count.
But I think, in all honesty, that hits the nail on the head. I ran as a Republican because I believe in the Republican tenets. I don't need to sign something that can come back to bite me to say that I'm a Republican. If I wasn't a Republican and believed in the majority of the platform and everything else, I'd be running as a Democrat. And I think that at this point, we got to just go with you ran as a Republican and have the Republican Party in primaries vet out the bad potential Republican judges. Thank you.
Thank you, Fred.
Point of information, how many more speakers do we have?
I don't know, probably 50-ish.
Thank you, Judge. We had
Mr. Chairman, I would move, I don't know that we have any meeting. I would move that the delegates reserve their questions and not be, or I'm sorry, not the delegates, that the members of the committee not be permitted to ask questions of delegate, and we only have testimony only.
We got 24 people coming up.
Second. Fourth. Microphones.
Been moved and seconded that we not ask any questions of the delegates. All in favor? Do we have any discussion on that motion? Seeing none, all in favor say aye. Aye. All opposed, nay. Nay. The ayes have it. Okay.
SD 17 Sophia McFridge, SD 17 Margot Creekmore, and SD 17 Judy Nyagard.
Dear committee members, thank you all for your service on this. My name's Sophia Maffridge. I am from Harris County, and I have been a judicial candidate 5 times. I have been in contested primaries and been the Republican nominee 3 times. I speak to you also following what Mr. Rogers and Mr. Schuchart just said to you regarding Rules 44, 43, and 44. On Rule 44, y'all are removing the exclusion of judges, attorneys, judges of the peace, statutory district judges, courts of appeals, courts of criminal appeals judges from the definition of office holder. That definition is what tells you who is subject to the rule or not. That's why this is such a huge concern for those of us that are attorneys. I'm a 36-year litigator. I have served this party in many different capacities. But if we do this, if this committee goes forward with this, as Fred said earlier, it will be impossible for us to fill those seats. Those of us in Harris County that are litigators now can't even tell our clients if a judge is going to follow the law in their case because there are so few Republicans that have the bench. We're making strides against that, but please consider the effect of what would be done here if you do not go back to the exclusion of the judiciary and the attorneys on this. I want to go ahead and read to you because there were a lot of questions as far as why the judicial canons do not allow us to talk about certain things when we run for judge. And by the way, times when we have been unsuccessful as Republicans, I've had Democrats say to me, well, you should have run as a Democrat and you would be a judge now, Sophie. And my answer to them is, I don't run as a Republican.
Time.
I am a Republican. If I may just read the canon real quick. Thank you. A judge or judicial candidate, and this is Canon 5, shall not make pledges or promises of conduct in office regarding judicial duties, other than faithful and impartial performance of the duties of the office, but may state a position regarding the conduct of administrative duties, and may not knowingly or recklessly misrepresent the identity, qualifications, present position, or other fact concerning that candidate or opponent. So this binds us from making any comment on any issues. We ask that you please reconsider your position. Thank you for your time.
Margot and Judy. Margot Creekmore. Judy Nygaard. Peter Bowen, Sheila Bernhard, and Jerry Fuller.
Good evening. My name is Judy Nygaard. I am a delegate for SD 17 in Harris County and have served as presiding election judge in many elections.
Mr. Chairman, I'm sorry, could you speak a little closer to the microphone? It's hard to hear.
Is that okay?
That's better, thank you.
Our democracy depends on election integrity, and our election integrity is being challenged. Changing the verbiage U.S. citizen to registered voter is rife for voter fraud. To my knowledge, the Texas Secretary of State does not certify citizenship when registering online. Anyone can do it, including the millions of illegal aliens who have been flooding the borders since the last stolen election. The upcoming election will see an increased number of provisional and reasonable impediment votes that, in my opinion, many will be questionable. Are you willing to risk 4 more years of corruption and incompetency? I am not. Thank you.
Judy. Peter, Sheila, and Jerry.
My name is Peter Bowen. I'm a delegate from SD 13. And I propose an amendment to Rule 44 in relation to judges, such that if a judge rules within the discretion allowed by law in a manner which is inconsistent with the Republican Party legislative priorities, that judge may be censured. In other words, what I'm saying is that under no circumstances should a judge be censured for following the law. But when the judge has discretion in the way he applies a ruling, such as how many days a father can see his son or daughter, or whether or not a parent should be allowed to mutilate their child, those kinds of things, to me, are with censure because they're bad decisions, unfair decisions. And so I have my little thing written out if you want it.
It would be best to give it to your SD representative on this committee.
So I should give it to them?
You're Senate District 13?
Yeah.
Okay, 13.
Rachel, where is she?
Rachel Hooper.
Oh, yeah.
There you go. Go give it to her. Okay, SD 17, Sheila Bernhard. SD 18, Jerry Fuller. SD 30, Deborah Avayaro. Yeah, we got a sign-up sheet right here.
I'm Sheila Bernhardt. I'm from SD 17, brand new precinct chair. So I'm just speaking in support of keeping the word citizen, keeping the citizenship clause in the question of eligible voters. I believe that removing that word and allowing only registered voters will open us up to a lot of different questions. I feel very strongly that we need to have strong, honest elections, and that there's enough that we need to have to worry about with election integrity, that citizenship should always be reserved for American citizens. And I thank you very much for your time.
Thank you, Sheila. Senate District 18, Jerry Fuller, and Deborah Avaro.
My name's Jerry Fuller, SD 30. What I'm asking is please reconsider 8N by reason of, I also observed and witnessed a long ongoing time of the Republican Party basically getting shut down. It was no meetings and nothing, and that kind of works itself out if you want to wait a couple of years, but that's a lot of time to lose because you always have an election where you get somebody else. But if you would change, just to offer a suggestion, change the voting requirements, something that gives your body a way to resolve a problem instead of having to lose a year and a half or a year or 2 years, whatever it takes, to hold an elected person accountable. It's extremely frustrating for 150 people to try to do business and not be able to based on that. And so just please give it some consideration. Thank you.
Thank you. Does the Honorable Matt Rinaldi want to speak? Is he even here? He signed up. He's already gone. Okay, Deborah Avaro, SD 30. Bill Mitchie and Jeff Murphy and Ron Carr.
Hello, thank you for listening. I'm Deborah Avellano, delegate from Senate District 30, Denton County Precinct Chair for Precinct 2073. I'm asking you also to reconsider Rule 8N. We in Denton County experienced a lot of frustration due to our county chair's rogue behavior, dismissive of Republican Party of Texas rules and Robert's Rules of Order when conducting CEC meetings. When he was challenged, he signaled his sergeant of arms to shut down the meeting. And then he stopped having meetings altogether. So therefore, no precinct chairs were engaged or prepared for the election season. It crippled us, really kneecapped us, as far as being able to build up our county and prevent it from turning blue, because we've been trying to get our school boards and our local elections over, and we can't do that if we don't have precinct chairs that are engaged. We attempted to call special meetings, and he sent out appropriate calls for meetings. He sent out a letter to counter it and called it off. Right now, we felt trapped. We had to wait until he decided to run for a higher office. Right now, we need to be able to take action to counter any kind of authoritarian chair who's only using that position as a stepping stone for his own ambitions, so we can have true leadership in the county operations. Please consider Rule 8N to give the precinct chairs some check and balance as to someone who's using power inappropriately. Thank you for reconsidering this. We appreciate your time.
Okay. SD 17, Bill Mitchie. SD 17, Jeff Murphy. SD 17, Ron Carr.
Hi, my name is William Mitchie Jr. I'm in SC 17. I'd like to talk about Rule 46. I understand Rule 46, the requirements for voting was changed to require the voter to be a registered voter in the state of Texas, and remove that the voter would not be a U.S. citizen. At least that wasn't stated. I'd like to see both of them be in the requirement, that you are a U.S. citizen and that you are a registered voter in the state of Texas. Thank you very much.
Jeff?
I think you're going to notice a theme here with the people from SD 17. Jeff Murphy, Fort Bend County, SD 17. For Rule 46, I agree with the comments that have been given by my colleagues in SD 17 about including the register, like that in addition to being a registered voter, that you're a U.S. citizen. I think especially when we look at the other items that we've been talking about here at the convention, for example, the plank in the platform where we talk about adding in that the focus in on U.S. citizenship and the importance there. I think we want to make sure that we're addressing that in this language as well. I support the principle. I support that we have this as a rule while we work through whatever we need to do to push it through legislatively. But I think ultimately we need to make sure that we're focusing in on the closed primary that has U.S. citizens who are registered voters voting in the Republican primary. Thank you.
Ron Carr, SD 17, Tom Kellen, 17, and Gail Bain, 17.
Good evening. My name is Ron Carr, and I'm a Adopt a Precinct lead for 973 in Houston, Harris County. I'm also a member of the HCRPG Ballot Integrity Security.
Can you please step up to the microphone?
Ron Carr, Harris County, Precinct 0973. I'm Adopt a Precinct lead, and I'm also a Harris County Republican Party Ballot Integrity Committee member. And like my other colleagues who were up before me, I too am very concerned about the upcoming potential rule change 46 as it applies to the wording citizen versus registered voter. I just wanted to add a maybe what if to the reasoning for my concern. And the what if is, we all know of tens of thousands of illegal aliens that have been crossing our southern border. And what if the rules get changed to allow registered voters, and you have somebody from Iran that's, let's say, has only been in Harris County for a week and a half, but they have managed to obtain one of these, and they're a registered voter. I can't begin to think of the fear that I would have if hundreds or literally thousands somehow manage to get to be a registered voter and get one of these, and next thing you know, they're voting in our elections and they're not a United States citizen. So please help me register your concerns as well so that this rule number 46 does not go any further. Thank you.
Tom Killen, 17, Gail Bain, 17, Clyde Neal, 17. You guys are busy.
Tom Kelly, Colorado County Republican Party Chairman, SD 17. I'm here to testify on Rule 46. Yes, Caleb came in this morning, your committeeman, Caleb came in and told us about the potential rule change where they change the language. And I just want to say that what I would like to see, and what the people that we talk to after that would like to see, both of those terms be in there. Not only leave it as United States citizen or citizen of the United States, but add also registered voter of Texas. Add both of them. I've been in the insurance business for 25 years. I have seen, for 25 years, I have watched policyholders take advantage of policies because something was either too specific or not specific enough. I can't tell you enough. You just got to cover all your bases, dot your I's, cross your T's. Too much is better than not enough, but just add that on it. But I'd like to see both of those terms be in Rule 46. But I do have a question to the committee. Did all of y'all talk about what Caleb talked about in your Senate districts this morning?
It was an oversight. We didn't, I mean.
You can't speak for the full committee, speak for yourself.
Yeah, I'm speaking for myself. I made that amendment to strike United States citizen and add Texas resident. I made that. As soon as I heard y'all talking about it, it was like
Chairman, this is out of order.
a lightning bolt. Oh, I'm so sorry. We passed a rule. I'm sorry.
That's all right, and I didn't mean to cause any problems there. It was just kind of funny that SD 17 is, we're on it, and there's none of the other SDs are talking about it. So I was just curious, if, what's up with Caleb and that. But anyway, that's my thoughts on Rule 46. Thank you for your time.
Thanks, Tom. Okay, Gail Bain, 17, Clyde Neal, 17, Dawn Alexander, 17.
Hello, I'm Gail Bain.
Can you
SD
please pull the
17.
microphone down to your mouth? Yes. Thank you.
I'm Gail Bain, SD 17. Thank you, Mr. Chair. Thank you, committee. We appreciate everything that you do for us. I'd like to speak in regards to Rule 46. I respectfully ask that you include the terms U.S. citizen and registered voter in the state of Texas in the language of this rule. While some people may think that this is redundant, I believe that it may further clarify the sort of issues that may occur for election officials. I believe that this will assist with election integrity. Please consider my request. Thank you.
Clyde.
Mr. Chairman, may I be recognized? Would it be appropriate, Justin Nichols, SD 26, would it be appropriate to go ahead? I don't know that there's a lot of dispute over this issue. Would it be okay to just take this up right now, fix it, and then we might resolve a lot of this issue?
If that's in the form of a motion, we can vote on it.
I'll move to suspend delegate testimony at this time to take up that specific issue in Rule 44.
I'll second.
46.
Okay, it's been moved and seconded that we temporarily suspend delegate testimony, take up the issue that's been raised multiple times on the U.S. citizen versus Texas registered voter, and then resume back to delegate testimony. All in favor, say aye.
Aye.
Opposed, say nay. Nay. It carries. Okay, if the delegates just stand by for a moment.
Mr. Chairman,
yes, sir, Rick.
point of information, please.
Rick had his hand up first.
Mr. Chairman, I sent Jerry a proposed amendment for 46 to deal with this issue. Oh, and I move that we take that amendment. Oh, okay. I have to go find it. I have to go get it again. The motion is, in the first paragraph of Rule 46, between only and registered, we add U.S. citizens who are, and on the next line, or in the beginning of the next paragraph, where it says a registered voter, I suggest we add United States citizen who is a.
We have to stand at ease for just a minute while we get the right document up.
Can we go ahead and vote on reconsideration?
Sorry?
Can we go ahead and vote on reconsideration?
We can vote on reconsidering, yes, we can do that. We need to, hang on a second, Leslie.
We are a new committee, so we're not reconsidering anything, is that correct? So we don't need to vote
Sorry?
for reconsideration? We are a brand-new committee.
Well, essentially, I took Justin's motion was to bring up Rule 46
Suspend the
and,
rules. It was to suspend the rules. Now we can go to the rules, but we don't need to reconsider this because we have not.
yeah, okay, I get it. Yes, thanks for that clarification.
Yeah, I also took that as permission to open 46 for amendment.
Yeah. Kind of in the way we did it last night on very narrow opening on issues.
That was my point of information,
Yes.
Mr. Chairman. We want to make sure that we're opening only for this specific purpose and for nothing else in that rule.
Correct. Yes, Rachel.
Mr. Chairman, Rachel Hooper, SD 13, doesn't this permanent committee need to first adopt the rules of the temporary committee?
That is probably correct. Would y'all like to go ahead and do that, and then we can bring these up as they come up? I think that would be procedurally a little bit cleaner way to do it. Okay, it's been moved that we adopt the report of the Temporary Rules Committee. Do I have a second?
Second.
All in favor, aye. Aye. Any opposed, nay? Okay, we've adopted that report. Thank you, Rachel.
Technically, we weren't open to doing anything until we adopted these rules. So it was moved. Mr. Chairman, point of order. Just so that we are clean, the previous motion was out of order because we had not adopted the rules. We technically, I would believe, need to, now that we have accepted these rules from the temporary side into the permanent committee, that we now need to reassert the motion to open this amendment, or open this rule for amendment. For that specific purpose.
Mr. Chairman.
Yes, sir.
Bruce Campbell, SD 24. As we started, we were just listening to testimony, so we would have probably done some things in a different order if we'd reached the end of testimony, such as the rules we had for this committee do not carry over unless we adopt the rules for the committee that we had before, if we want to keep those.
It's not required that we have rules, but your point is well taken. Do I have a motion to re-adopt the rules we used for the temporary committee?
I move we adopt the rules we used for the temporary
Is there
committee.
a second?
Second.
All in favor, say aye. Aye. All opposed, nay. The previous committee rules now carry over to the permanent rules. Thank you, Bruce.
And Mr. Chairman?
Yes,
I
sir.
believe the motion that was made to open 44 for this specific purpose is also moot 46 rather, was moot because it was prior to the time that we authorized these. So we need to go through the process again of reopening.
I don't agree with that, but let's go ahead and do that anyway to clean it up, and there's no challenge for it. Justin, could you make your motion again?
Justin Nichols, SD 26. I'll move that we suspend delegate testimony for the purposes of taking up Rule 46 for the limited amendment about which testimony has just been taken.
Second.
Seconded. It's been moved and seconded again. All in favor, say aye. Aye. All opposed, nay. Okay, now are we legal, Mike?
You're good.
Okay, now we've got, I believe, the right document on the screen. Y'all probably have it on your laptops in most places. Do I hear an amendment to take care of this issue? Yes, no, that's not Leslie, that's Rick.
Rick Cook, SD 23. Same motion I made earlier. I dropped the Word document snippet into Signal as well. But the proposed amendment is in the first paragraph, between only and registered voters of Texas is to add United States citizens who are. And in the second paragraph, first sentence, between a registered voter, I would add between a registered and the a registered voter sentence, add United States citizen who is a. So it would read, only United States citizens who are registered voters of Texas who qualify to vote as Republicans in accordance with that part would, and then a United States citizen who is a registered voter of Texas qualifies to cast a vote in a Republican primary election, etc.
Can we highlight it so we can see it?
Okay, can you say that a little bit slower so our secretaries can catch up there?
Sure. Okay, in this context, on the first line where it says only, right where you are, but so after the only, put United States citizens who are you don't need to add all the registered voter part, it's already there. It's just United States citizens who are. And then on the second paragraph, right after the A, add United States citizen who is a. Second paragraph, between A and registered. No, right after the A, at the beginning of the paragraph. Yeah, right there, yeah. Insert United States citizen who is a. With the G turned to an H. Oh, and citizen spelled right, yeah.
Okay, is that your motion, Rick?
Yes.
Been moved and seconded that we take essentially the testimony of SD 17 delegates and perhaps others to insert United States citizens who are in first paragraph and United States citizen who is in the second paragraph. Does everybody understand what we're voting on? Is there any further discussion? Yes, Eric?
Mr. Chairman, I rise to speak against this motion because it has the effect of disenfranchising the members of the United States Armed Forces, their spouses or dependents, or U.S. Merchant Marines or spouses or dependents, or U.S. citizens who are domiciled in Texas but temporarily living outside the territorial limits of the United States. that are eligible to vote a federal postcard application. These individuals are not registered voters of Texas, but they are eligible to vote in Texas elections, in federal elections in Texas specifically, and state elections pursuant to the Military and Overseas Voter Empowerment Act. And so when we add language like this that conflicts with how federal and state law work with regards to voter registration and other voters, we create problems separate from how the elections work in this state. And so I have a motion by substitution for the entire section, the entire rule, that I can offer. But if you want to consider that at the time we take up the entire rule, I can do that. But I wanted to rise in opposition to this language because it would have the effect that I just stated.
Okay, without objection, I'd rather wait till after we do all the delegate testimony and dispense with this part first, and then we can take it up again. Rachel, were you speaking for the amendment?
May I move to amend?
Yes.
Rachel Hooper, SD 13, moved to amend by adding the language after registered voter of Texas or member of the United States military.
Okay, the amendment is to add, I believe, Eric's concern, where it would read United States citizens who are registered voters or members of the U.S. No, that's not right. Say that again.
Members of the United States military and their spouses.
After Texas?
Yes, in both places.
Does that just be a friendly amendment?
And their spouses.
Mr. Chairman, can that just be a friendly amendment?
I would accept that as a friendly amendment.
Is that a friendly amendment, Rick?
Yes, I would accept that as friendly.
A committee of a few very intelligent people around me would like it to say United States military and their dependents. Spouses and dependents.
Let's get this wording just right first, Rachel. Then you can speak to your amendment. In the second.
Mr. Chairman, would it be considered a friendly amendment to add to, or members of the United States military and their spouses who are domiciled in Texas? Because I could see this going out of state in a hurry.
I believe that would change the meaning a bit, so I'm going to rule that not a friendly amendment.
Well, I propose an amendment to the amendment then to add that language. And their spouses who are domiciled.
Wait.
Oops, I'm sorry.
Hold on just a second. Rachel, let's get the second part of your amendment, your friendly amendment, correctly worded grammatically.
So the problem is the first paragraph uses United States citizens plural, and the second paragraph is singular. Only United States citizens. Okay, I see you. And their spouses or dependents.
No.
So how about or a member of the United States?
Rachel, clarification. Did you want dependents in there in addition to spouses?
Yes.
Okay.
Yes. And then singular in the second paragraph.
Point of information, Ronnie Jones, SD12.
Yes, sir, Ronnie.
Anyone over the age of 18, they are their own registered voter, correct? Or dependency has nothing to do with registering to vote. Correct?
I'm not advised.
Thank you.
Mr. Chairman, could we move as a committee of the whole just to solidify this language as a whole and then vote on it? Could, like, as a working group, we've done that before. Is that needed?
I think we're almost there.
Okay.
Mr. Chairman, inquiry?
Who was that?
Bruce Campbell, SD 24.
Yes, Bruce.
My question is what the word "or" does. Do you need to have, after it says United States citizens who are, does it need like a semicolon there so that the "or" is registered voters of Texas or members of it? Otherwise, I think the "or" goes all the way back to United States citizens who are registered voters of Texas or. And so the "or" really should just be registered voters of Texas or. I think you need some kind of punctuation there, semicolon or whatever. I'm not an English teacher, but
Can we let the grammar and editing committee handle that? Okay.
well, it makes a difference on what you want the "or" to mean.
The meaning will change. We don't have the punctuation correct.
So, Rachel, as the proposer of the amendment, would you prefer to put a semicolon in there?
Or adding
Or
the word
comma or whatever?
"who are either."
I like adding the either.
Okay.
Adding "either," I think, accomplishes it after the word "are."
Yeah, who are either registered voters or members. That,
Do we have members of the military that are not U.S. citizens?
Yes. Wichita Falls, over half of the deployment there at the NATO training base are who are foreign citizens.
Okay, I think I saw a hand in the back. No?
I'm just a dependent.
Okay, that was taken as a friendly amendment. Do we have the language correct up there? What are we waiting on, Jim?
No, did we agree on the word "either" as opposed to punctuation? Who are either registered voters of Texas or. That way it applies to both.
You don't have voting age dependents.
I think you need both, not one or. Brandon.
Mr. Chair, Brandon Hodges, SD 31, just point of information. I believe it was the chair's, you were trying to make this quick because we thought it was going to be a quick fix. Since it's not, and it's going to come back later, would the chair consider us maybe calling this and then coming back to it later while people work on the language so the delegates can, or we can take testimony again?
Yeah, the proper way to do that would be to us to vote on this, vote it down, and then vote it, or reconsider it once we get finished with delegate testimony.
Can we
could
lay
do
it on the
that.
table? I
We could
motion
do
to lay it
that.
on the table.
Okay, we've got a motion to lay this on the table so we can get back to delegate testimony. It's been seconded. All in favor, say aye. Aye. All opposed, nay. The ayes have it. Yeah, thank you, Brandon. But don't delete that. Come back to it. Okay, where are we on the delegate list now?
Clyde Neal, Dawn Alexander, Michael Walton.
Clyde Neal, Senate District 17. Clyde Neal, Senate District 17. I'll be brief. I am here to speak about the citizen wording on this. And I appreciate everything that the committee is doing and where y'all are. But I'll just be on record as supporting what you're doing now to add citizenship back into the requirement for all the reasons that my colleagues have said. Okay, thank you very much. And thank you for all of your work on this. It's really appreciated.
Dawn and Michael.
Dawn Alexander, Fort Bend County, SD 17. I just wanted to add my 2 cents in on the Rule 46 change of leaving out citizenship of the United States as a requirement for voting. I would also like to see both of the things included. A rule regarding citizenship of the United States and also the registered voter in Texas. Thank you.
Michael Walton, SD7, Melody Cook, SD17, and Clint Stutz, SD3.
My name's Michael Walton. I'm a precinct chair in Harris County, SD7. And I'm regarding, or actually I'd like to address Rule 43. I propose that several word changes addressing where the platform was referenced to add in addition to that the legislative priorities. In an effort to make our legislators more accountable to the grassroots, I'd like to propose that where the platform is referenced in the rule, that the legislative priorities be included as well and require rather than request candidates agree or disagree on the priorities list. Have that wording added, that'd be great.
Okay, Melody Cook, Clint Stutz, and Terry Wilson. Melody, Clint, Terry Wilson, Lincoln Achille.
Hold the microphone to your mouth, please.
Hi, I want to thank you guys for doing this and being here.
Terry Wilson.
SD 12. And I'm just asking that you guys reconsider rule number 8N. I live in a county where the county chair failed to schedule a meeting for about 1.5 years and halting the business of the party. Basically, it was holding the party hostage and silencing the voice of the precinct chairs. I think there should be a way to hold elected officials accountable, and using a simple quorum present at a meeting as opposed to needing 60% of all precinct chairs, even those that are not in attendance, because some of the precinct chairs actually never show up. So I think the voters deserve better. There's got to be a way that they can hold business and that we hold them accountable. Thank you.
Clint Stutz, Lincoln Achille, and J.J. Brookshire.
Clint Stutz, SD3. I've talked about this before, but I'll bring it up again. In Rule 14, the title of it is Open Meeting and Right to Testify. And then close to halfway down, you see this sentence that says, this privilege shall include delegates and alternates under challenge at any convention pursuant to Rule 35. All I ask is that you do a quick amendment to this, strike privilege, Replace it with right. Very simple, very quick, 2 minutes. The last thing I want to talk about is 44 and this judicial exception. Please add the exception back in. I know there's bad judges. I get it. We see it everywhere. But this is not the remedy. Please add the exception back in. Thank you.
Lincoln of Chile and
Lincoln Achille, SD 12, Denton County. I would like to ask the committee to reconsider the requirement of Rule 8N. We've heard much testimony on this regarding the conduct of the county business meetings, or in some cases, a large case, the lack thereof, that resulted from a bad county chair. Where I wanted to expand upon this is that I think it's important that we lower the threshold of application of this rule, because not only does it not bring the requisite justice to the county chairs or any other precinct chair who may be derelict or abuse their duties, it also has a deleterious effect on the turning out of the vote. In the case of Denton County, we have not only a chair who was unable to be sanctioned because he continued to not have meetings, he has then moved on to run for a Senate district office in a district in which he does not reside, giving some of those affected precinct chairs the hope that the legal system would intervene. However, the legal system has had, in practice, a relatively hands-off approach to elections, and the stalling of those hearings has further delayed justice. Justice delayed is justice denied, and as Republican voters, particularly those in the primary, start to see the application and implementation of a de facto patronage system, it really makes you wonder if the whole thing is not, it has the appearance of it being scripted, even though we know as we work hard to try and turn out the vote and spread these principles, if it's impossible for local precinct chairs to hold their local officials accountable in a volunteer area in which we're all united under the same common goal, I shudder to think of what the long-term consequences are. So I think for that reason, it's important that we lower the threshold of implementation of this rule so that bad county chairs can reconsider such a course of action, and it will also foster, it will engender Republican voter turnout, and it will improve the volunteer base of people who want to participate, knowing that everything that happens is not a scripted foregone conclusion in advance.
thank you. Deborah Bell, SD 27, Bonnie Elbert, SD 27, Jesus Martinez, SD 27.
JJ Brookshire, SD 22, and I'm speaking on some changes I'd like to see done to Rule 30 and Rule 42. The Republican Party of Texas is driven by a populist movement drawing strength from our grassroots. Currently, the only way a Republican can vote for their SREC representative is to take time off from work and pay hundreds, if not thousands of dollars to attend the state convention. This effectively equates to the largest poll tax in history. By moving the election of the SREC to the SD conventions, we encourage greater participation on the local level. We remove the high cost of having a direct voice in who sits on the SREC. We encourage SREC members to maintain open communication with the county executive committees and Republican voters within their SD throughout their term. Many ask, how can we expect to hold simultaneous elections in multiple locations? The answer is simple. If Iowa can do it for the presidential election with nearly 2,000 simultaneous caucuses, we can do it for SREC elections. In 2016, 30.3% of eligible Republicans participated in the Iowa caucuses. Now imagine if we move the decimal place to the left, and even 3% of eligible Republicans participated in the SD county conventions in Texas. If we look at the number of votes received by President Trump in 2020, that represents over 175,000 voters. That is growing the base.
Okay, Deborah Peel. Okay. Bonnie Elbert and Jesus Martinez.
If there's others that wish to testify that are not signed up at the front, please come do so.
Deborah? Okay, all righty.
Hello, my name is Deborah Bell, and I'm the county chair-elect for Cameron County. Forgive me, I just ran over. For those who do not know where that is located, around the southernmost tip of the Texas border. I'm asking for consideration amendment to, I believe, Rule 46 on closed primaries. I would like the committee to consider adding words "or to keep open primaries" or consider an option for counties such as Cameron County to opt out. This simply allows counties that do not need primaries to opt out. How much time do I have? 2 minutes, okay. It is my belief that each county chair and CEC know what is best for their respective counties. Cameron County is the 13th largest county in the state of Texas with a population of 421,000 approximately. We have 231,000 registered voters. In our most recent primary, we had 4.6 of our voters labeled as first-time Republican voters, totaling 861 votes, which is significant for those of us in Cameron County. To close our primary would all but wipe out those votes. To vote Republican in Cameron County is something people only whisper about. They do not register to vote Republican. Out of 19 electable positions at the county level only, we have one Republican elected right now, one. And my job as the county chair is to recruit viable candidates that reflect our values. To close primaries in Cameron County would prohibit me from doing that. It would limit our votes, and therefore candidates are not going to want to run on our platform. It is nearly impossible to get constituents to register as a Republican, thus discouraging candidates from running on our platform. What the RPT is proposing will hurt my county in ways that I cannot even begin to fully communicate to you. We are here just now starting to make significant gains closing the gap in regards to Republican voter turnout. In 2020, we had 8,353 people vote in the Republican primary, but in 2024, we had 14,857. That is an increase of 44%. As a candidate in this past election, I cannot even begin to count how many times people called me, texted me, spoke to me in person saying they voted for me, but few wanted to openly admit it in public because I ran on a Republican ticket. The concept of closed primaries does not work for blue counties like Cameron County, and I'm asking you, the committee, to please consider an opt-out option for counties such as my own. Thank you for your time, and thank you for allowing me to speak.
Thank you, Deborah. Bonnie Elbert.
Mr.
Jesus.
Chairman,
Go ahead.
point of personal privilege, Mr. Chairman. Dwayne Wright, SD5. I would like to congratulate this young lady right here. She came up to me, was it 2 years ago?
Yes, sir. 2 years,
2
2022.
years ago, with the exact same complaints that we've heard from SD 17. And at that time, I told her that we should never let somebody hold us back, and that if she wanted to make the change, she should run for chair herself. And she did it. And
Thanks, sir. This is only my second convention and my first presidential one, so thank you for your time, and please consider my comments.
Bonnie, Jesus, and Ian Camacho.
Good evening, and thank you guys for what you're doing. My name is Bonnie Elbert. I'm from SD 27. I'm also a delegate from Cameron County and a precinct chair. And I want to speak to what Deborah just told you all. I have a personal story. 6:50 p.m. on election day, primary day, I get a call from one of my constituents, Bonnie. She said, they're telling me she went to vote. They told her she had to choose a ballot, Republican, Democrat. She went out to call me. She said, I'm confused. I've never done this. But I want to vote for Deborah Bell, Norman Esquivel, and Myra Flores. She said, I've only ever voted Democrat. She said, you know, I don't know what to do. And I said, if you want to vote for those three candidates on the Republican ticket, you have to pull a Republican ballot. She goes, I've never done it, but I'm going to do it today. And she did. That's just one story. It happened over and over and over again. And it's a testament to people getting out, creating relationships, espousing our values and our platform. But if you go ahead and implement Rule 46 as it stands and we're forced to close the primaries, we're not going to be able to do that. People like Melissa that called me will not vote. They grew up blue. It's going to take time and a process, but we're making huge progress there. And with a new county chair, Deborah Bell, and candidates like Jesus Ramy and others, I think we can flip Cameron County red. But a closed primary is going to shut that completely down. So if there is some way y'all would consider an option that would allow counties like Cameron County to opt out, we would really appreciate that consideration. Thank you for your time.
Jesus and Ian.
Mr. Chairman, how many more speakers do we have?
We got 3.
Okay, great.
1, 2, 3, 4.
Thank you.
Good evening, everyone. My name is Jesus Ramy Martinez, and I'm running for Cameron County Tax Assessor Collector. Now, regarding Rule 46, this is the first time I've ever run. This is the first time I've ever been to a convention, so it's pretty new to me. But I think that with Rule 46, we are affecting the whole county. For those that don't know, Cameron County is a blue county. This year was the first year that we got 5 candidates running in the Republican ticket, and we broke record because it's usually it's all Democrats. So by doing this, I think you guys are just handing over the county over to the Democrats, and I think it's unfair for all the new candidates that want to run because they won't have a chance. Thank you.
Ian, Eric Blake, Amy Hedke. That's it. After.
I can be heard, okay. Hi, my name is Ian Camacho. I'm a delegate in SD 22, and I wanted to speak to 8N that a few people have spoken to already. And I wanted to address the concerns raised by those in SD 17 and Denton County. And I also wanted to address what Mr. David Westbrook of SD 19 questioned, like what do you want us to do, what specifically? To some extent, you already did handle this with 8R, and I'm going to go into that. But there's also repercussions as the way 8N2 specifically is written. Because if we keep it as it is, the RPT and the chairman and precinct chairs, who are volunteers, could face potential legal repercussions. And so while we should absolutely try to punish bad actors, we do not want to harm innocent people or expose the Republican Party to needless legal liability or money loss. This is not something we're taking on like Rule 46. So basically, the prior concerns raised by 8N are already somewhat addressed in the new RPT Rule 8R, which gives the county requirements of quarterly meetings for 20,000 population, 4 times quarterly a year, twice for the under 20,000. This is great. You handled something not actually covered in the law. And actually now, under the SREC rules, people can write a complaint if they get 60% of the CEC to do it and pass it into their SREC. Fantastic, that part's handled. The problem is, under the election code 171.09, .029 A and B, it does, I will read it real quickly, but long story short, you have to have 4 or more meetings. It says, it specifically is the title, the removal of a precinct chair or county chair for abandonment of office. A precinct or county chair who has failed to perform statutory duties provided by this code or failed to attend 4 or more consecutive meetings of the county executive committee may be removed for abandonment of office as provided by this section. I'm going to fast forward to it. You have to write out the reasons why this person has precinct chair or the county chair has abandoned office, sent it by certified mail, and they get a response. I'm fast forwarding. It's a long code, but that's basically the essence. So the issue you're really facing now, and just to sum this up, 8N2 requires 2 meetings to be missed, whereas the election code states 4 for precinct and county chairs. I'm not addressing the SRECs.
Time.
Okay, but you may want to change it down. So, thank you.
Thanks, Ian. Eric, Amy, Margaret Wakefield, and Craig Hardy.
Eric Blake, SD 22, Ellis County. Thanks for finally getting the temporary committee docs up today, just before SD caucus. I know it's not your fault. It's the guys over the other side of the building. But please, 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 please change Rule 33 to make it next convention all committees must provide all delegates with read-only electronic access to the current state of the working documents, regular intervals. Real-time would be awesome. If you can't do real-time, at least 2 hours. Every 2 hours, give us a snapshot of what you're working on so we can see the wording changes as they happen and not 72 hours later. Yeah. For example, Virgil's amendments, he mentioned them on Monday. You said, we accept them. We didn't even know what they were until today. Next, I am now campaign secretary for Amy Hedke for chair, Amy Hedke for vice chair, Amy Hedke for national committee woman, because Rule 40 and Rule 41 have no time limit on when you need to file to run for one of those offices. You added a restriction in Rule 41 to say you can't file for chairs any later than 10 days before convention. You did not touch Rule 40, probably because RNC says you can't touch national committee woman rules on presidential years. But now the two rules are inconsistent. What's more, 10 days before convention? Where went the right to nominate? In the spirit of Robert's rules, you said the only reason we had a timing deadline of 8 a.m. was because of Supplemental Rule 9. Supplemental Rule 9 that we didn't even see as a body until 10:30 a.m. and didn't vote on until after the amendment to the amendment on undoing. You remember this morning, we did not vote on that rule to say that an 8 a.m. filing deadline was in place until after the deadline had passed. That is villaging people. We need to consider our nominations rule. I know you want 10 days before because of scheduling reasons, but if you can't allow somebody to nominate based on attending the convention and seeing the state of the convention, you're hurting the people's right to affiliate and nominate who they want.
Thanks, Eric. Amy Hedke, Margaret Whitfield, and Craig LaCarty. Yes, Wakefield.
Hey guys, Amy Hedke, SD22. I slipped into the legislative priorities room, and I've just been kind of watching that mess the last couple sessions now. And I'm about ready to just suggest you abolish the Legislative Priorities Committee and instead have all the resolutions from the delegates thrown into a numbered document and then let the delegates vote for their top 10. And the top 10 with the most votes becomes your legislative priorities, and the ones that didn't make the top 10 become the platform. Boom. You're going to have people automatically reducing how many they choose to push their preferences to the top. And I know that correct me, Mark, you probably remember, you guys probably do, when legislative priorities was implemented, we didn't have numbered planks. They were just sections that were whole scale all over the place. But we have the Scantrons. We have, it seems to be an easy fix. I'm sure after 3 conventions it will be a mess too, because that's the way human nature seems to go. But I figured I'd throw that out this time around and let you guys chew on it for the next couple of years. So I don't expect it to be amended today, but I think it's something worth looking at after seeing the bullet point mega planks that everybody is putting in to try to reduce the platform. You're going to have fewer numbers and more pages at this point. So that's pretty much it for me.
Thanks, Amy. Margaret Wakefield, SD 17.
Thank you for the opportunity. I'm new at this. Forgive me for having to look for notes so much. This is, I believe what I have to say is pertinent to several issues. First thing I'll discuss is a rule that's pertaining to Election Code Chapter 174. Election Code Chapter 174. Conventions, subchapter B. B, precinct conventions. Okay. Section 174.023, nature of, the notice of date, hour, and place of conventions. You know, we go to vote and we place our vote, and then afterwards, there's going to be a convention, a precinct. We want people to come. In accordance with subchapter B of chapter 174, I'm sorry for my stuttering, if there is a requirement that the chair announces gives the notice and of the place and time, and it says in this what I quoted, this location I quoted, rules, it says the chair of the county may announce it, and I understand the procedure is by computer, by electronic means, on the GOP station and the commissioner's court station, either of those two places. Well, if he doesn't do it, the rule is he may do it, and if he doesn't do it,
Time. Sorry, Margaret.
I think you should say shall do it. The next party is to do it, and I think the next party that's to do it should be shall instead of may.
Time.
Time? Okay, what about my next proposal?
You ran out of time.
Is what?
You have 2 minutes only.
You have 2 minutes.
2 more minutes?
No.
I
Your
can't
2
do
minutes
it.
are
No,
gone.
It's about electronic failure to have it go back to the
No,
original
no, ma'am.
before we had electronics.
Okay. Craig Liccardi and Glenn Milburn.
Evening, Craig Liccardi, SD1. I was going to say I have a habit of being the last person to go, but I guess I'm going to break that record. And being the last person in between you guys getting to finish up and go home or get out of here and adjourn. Anyway, I want to speak on Rule 43 and Rule 44, specifically regarding the judicial exemptions that have been there and are not there. And when it comes to Rule 43, I think we all know that it's inopportune for judges or judicial candidates to make known their political beliefs and where they're going to fall on any particular issue. And so I think reinstating that exception for judicial candidates in Rule 43, while it would be nice for every candidate to have to be able to say, yes, I believe in the Republican Party and I will go to my grave supporting every single one of our platform planks. Okay, that's not entirely reasonable, and so especially not for somebody in that kind of an occupation. So we need to reinstate that exception for the judicial candidates in 43. However, I think we need to keep it as it is in Rule 44 because we all know that there's rogue judges. We all know that there's things that need to be in place so that we have tools to hold them accountable. We've been hearing that a lot in this convention about accountability. And as a state and as a party, we've been moving towards more and more accountability and transparency. And so I think it needs to stay in 44, but please reinstate it, the exception back into 43. Thanks.
Thanks, Glenn. And Dr. Brooks McKenzie's our last one. Oh, I'm sorry. Is that near your place? Yeah, that's correct.
Apologies for coming at this late hour. Glenn Melvin from Senate District 9. I had proposed, and it went through the senatorial district, so it would require a motion to reconsider this again, but that Rule 29B be amended, adding a quorum for each temporary committee shall be 5 if the convention has more than 50 delegates. If the convention has more than 25, but less than 50 delegates, for each committee shall be 3 delegates. If the convention has less than 25 delegates, quorum for each committee shall be the members present. I we wasted a whole night pretty much with on a resolutions committee by us thinking that the quorum needed to be half plus one. So I don't care if you use my exact wording, but I feel that there needs to be clarification to what is quorum at a senatorial district. Thank you.
Thanks, Dr. Brooks McKenzie.
Hello, committee. My name is Brooks McKenzie. And just for clarification, all that craziness going next door and priorities about judicial accountability, that's one of my pet projects. So I'm very big on accountability. I know we have wonderful judges. I know many of them. I've met many of them over the years. And when it comes to the censure and 43 and 44, it's been pointed out to me, because I don't know. And actually 43 and 44 aren't my deal, but it's been pointed out to me by some judges I trust at the appellate and other levels, that this will be used to remove them from very key cases. Whether it's bogus or not, it will be an excuse to remove them for key cases where legislation might be turned because we required them to make this statement. So I would recommend that we remove them from the 43. I like the idea of 44, but having them go through with 43 might actually have them removed from cases where we turn around and get somebody who's not as conservative. And then we've just made case law in our bid to maintain a certain standard was actually used to destroy our standard. And that's all I have. Thank you.
That concludes the speakers.
Thank you, delegates. Yes, sir, Chuck. That was about what I was going to announce, but before we do, we just got word that Kristen has a family member that's been affected by apparently a pretty severe tornado, and I'm wondering if Mac might lead us in a prayer in that situation.
Let us pray. Almighty God and Father in heaven, we come to you at this time understanding the frailty of life. And as we sit here and discuss these things that are truly important, one of the reasons that we're discussing them, Father, is because they affect lives of individuals, and nothing affects the life more than catastrophe and potential loss of life. We pray especially at this time for Kristen and her family and the devastation that they've encountered, and any others, Lord, that you know may have experienced this. And we know that it's a risk in our state and in other places around this country. And we understand that it can happen. And we ask that you will lay your healing hand of comfort upon them and help them to deal with this at this time. And let us offer our encouragement and support to do the same. Help us to remember, Lord, that life is brief at best, even if we live to a ripe old age, that we're not guaranteed another second on this earth without your will. Let us always keep that in front of us and be motivated by it to conduct ourselves the way that we should and to continue to show the love for one another that you have directed us to do. We thank you for allowing us to come to you and petition you for these things, and that we know that you will hear us. Please be with them. In Jesus' name, amen.
Amen. So I will propose that we take a 17-minute break, and that those of you that were working out the wording on the amendment that we tabled, if y'all could use this time to try to perfect that wording.
It's done, but Mr. Chairman, what is our schedule for this evening? In the past, there's been a time certain that
We
had
have to be out of here by 11 o'clock. I would certainly entertain a motion to be out earlier than 11 o'clock. But right now, we can be here till 11 o'clock if we don't have such a motion.
But, like, when do the rules need to go to the printer?
they need to go, I'm not advised exactly the time, but that's exactly why we'd like to get out before 11, like perhaps at 10 at the latest, 9:30 even. And the reason is that the editing committees have to perfect these before they go to the committee. And the platform will likely go even past 11 perhaps. And so if we can get legislative priorities and rules done in advance, then that final editing committee will not have quite the task hitting them all at one time.
Great. I have a motion or two, but that's it.
Okay.
Mr. Chair.
Okay, so let's be back here at, let's see, that'll work out to be 5 minutes till. 5 minutes till. Thank you.
Point of information, Mr. Chairman, are we coming back to 46 later, or do we need to offer all of our amendments to 46 right now before you get off?
Well, actually, let's do what we've been doing and vote to open up the particular rule that we are working on. The previous committee vote was just for that specific reason, so this one would be to open up 32 initially. Is that the right number?
That's correct.
Let's come back to 46 at that point, if we need to. Yes, okay, Nate.
And I'll speak to this right quick.
Well, wait a minute, we need to do the vote. So your motion
yes.
is to open up rule number 32?
Correct.
It's been moved. Do we have a second? Second. Moved and seconded. All in favor of opening up rule 32?
Point of order. Can't we have a discussion about this? I don't even know what
We
this is
can
about.
we can have a discussion of this. Okay, Nate, you want to talk briefly about it before we actually put the amendment on?
Yes, so this is to open up Rule 42 as it relates to how, 32, as how SDs and CDs submit their information specific to legislative priorities and resolutions to the state chairman and committees. Today, it can kind of be all over the place, paper, electronic, a little bit of everything. And this is to codify. This would be something electronic to be determined by the SREC, and that to be worked out. But this is just to try to help move that along and get us a little bit more efficient. And this was brought to us by Matt Patrick, the chairman of the resolution or platform committee.
No, it was brought forward by Nate Joy.
By me, but yes,
So-
via, yeah, sorry.
Okay, so are we ready to vote
Point of
on
information.
the, wait a minute,
Point of
Chuck?
information. Yes, sir. It's my understanding, I thought that we were under new rules, we're not under the rules temporary, that now we're starting all over again. So do we need to ask permission to open up every single?
We've already actually adopted the temporary rules report. So if we do nothing else, that plus what we just did on 46 become the permanent rules. So we're opening up this one at a time, really a matter of efficiency. Let's
Mr. Chair,
see. Yes,
just-
ma'am.
I can't see it. Could someone read it or either make it bigger, one or the other?
That would be a good idea, but let's vote to open it first. All in favor of opening 32 to accommodate Nate Joy's amendment from Matt Patrick, say aye. Aye. All opposed, nay. Okay, Rule 32 is now open.
I move to amend 32 to the said language.
Been moved and seconded. The language, if I'm paraphrasing in the interest of time, basically makes it required that resolutions be submitted electronically. I think there's another place in the rules that require that, or that say the SREC may specify the actual form of that submission. Is there any discussion, or do we have a second on that? Yes, we do. John seconded it, okay. Is there any discussion on this, for or against? Seeing none, all in favor say aye. Aye. All opposed, nay. It passes. Thank you, Nate. Okay, let's see, Rachel.
Rachel Hooper, SD, what SD am I? 13. Thank you. Where am I? I move to amend Rule 43. I would like to open Rule 43 to amend it to add a sentence at the end that says, "This rule shall not apply to judicial candidates."
Okay, it's been moved and seconded that we open Rule 43, presumably based on the testimony we heard. All in favor of opening Rule 43 now signify by saying aye. Aye. All opposed, nay. The ayes have it. Rachel, would you make your motion?
My motion is to amend Rule 43 with a sentence at the end that says, "This Oh,
But we've got it there already, right? We can fix it after we can fix it, yeah.
43. A sentence at the end, and the sentence will say, this. Add it at the end, this. Rule. This, THIS, rule, here, you want me to type it?
Oh, really? I like that.
Rachel. Okay, the amendment, and y'all should turn on track changes or something on there, but it reads, the rule shall not apply to judicial candidates. Is that right?
Yep. Second.
That's right.
Been seconded by Eric. Any discussion?
Speak in favor, yes.
Okay. Mike?
I just said that, yes.
Oh. Any opposed? Seeing none.
Point of clarification, Mr. Chairman.
Sure.
Do we, for clarity, need to add an office holders on that or not?
I don't believe so. I think that would include both. But
Office holders are candidates when they run.
when they run, yeah, right.
That's why it was a point of clarification.
Sure.
And I'm clear.
Okay, any others want to speak for or against? Yes, Dwayne.
I'd like to speak for.
Okay.
Dwayne Wright, SD 5. I believe my prior testimony is aligned behind the fact that I would support this this amendment. I believe the prior testimony by the judges and the attorneys was very relevant to this, and I support it wholeheartedly. Thank you.
Okay, anybody else speaking against? Seeing none, all in favor, say aye.
Aye.
All opposed, nay. The amendment's adopted. Thank you. While we're at 43, I heard at the break that on platform and principles, I believe, 43A, there might be an amendment. Is that true, Kathy? Okay. Do we want to open 43A? Is that your first motion?
That's 43, where we are.
Oh, it's just 43. Okay.
It's already open.
Okay,
Oh, it's
go back.
working now. Yes,
It's
sir.
already open. We don't have to reopen it. So what
Yes,
is
sir.
your amendment,
I think this
Kathy?
will be pretty quick. So there's 4 different places in the title and 3 different places in the paragraph. I did submit this language to everyone. Wherever it says platform, we would just add 3 words, and legislative priorities, so that the new title would say platform and legislative priorities review. And then the 3 times it refers to the platform in the text, it would say and legislative priorities. That's the whole amendment.
Second it.
Second.
Okay, it's been moved that throughout the title and the paragraph under Rule 43 that we simply add and legislative priorities to the language. Is that correct, Kathy? Is there a second? Second?
It'll be candidate platform and, candidate platform and legislative priorities review. So review goes on the other side of and legislative priorities in the title.
That's fine. Or you could just put and legislative priorities in front of the word review. No, that looks good.
It's once in the title and 3 times in the text.
It's third line
I think
down.
you're missing
Third
first line.
down.
First line. Maybe it's 4 times in the text.
And the
First
very
line.
First line.
From the platform and legislative.
There you go.
We good? All right. You have a backup,
like,
a backup
yeah,
skill, Rachel.
okay.
Okay, it's been moved as described to add legislative priorities to Rule 43. Any further discussion for or against? Leslie?
I'm sorry, one more correction. That last time that it's in there shouldn't be there, where it says at least 10 line items from the platform. I don't want and legislative priorities in there. We want another 10 items from the platform strictly that the candidate strongly supports, because there's only going to be 8 legislative
so the
priorities.
fourth
So just
in-
don't do the very last place where it says and legislative priorities, delete that one.
So the fourth one.
That one,
yeah.
yes, just delete that one and put it back like it was. Thank you, I'm sorry.
Okay, does that accurately reflect your motion?
Yes, sir, thank you.
And was there anybody wanting to speak for or against this one?
Can I have a friendly amendment, Mr. Chairman? Right where you are, it doesn't read well if you just put a comma and get rid of the "and" in front of the legislative priorities right there. Chairman shall also request that each candidate read the entire platform, comma, legislative priorities, and indicate. Oh, no, I'm sorry. Never mind. Strike that.
Okay, ready for a vote? All in favor of Ms. Hagler's amendment to Rule 43, say aye. Aye. All opposed, nay. The amendment passes almost
Mr. Chairman.
unanimously. Okay, do we have another amendment? Yes, Dave.
Yes, Mr. Chairman, I submitted to the Secretary an amendment to Rule 44. I can explain it briefly just for the open up vote.
Okay.
What it does, it makes sure that when an official is censured by a CEC, that only the constituent precinct chairs in that CEC vote on the censure. So, for example, if he only covers a portion of the county, that portion of the precinct chairs would vote on the censure, not the ones that aren't a constituent of the official being censured.
Okay, so if you're talking about if you had a representative district that went through a county on the county line, that only those in that district would be able to actually vote on it.
You hit it.
Okay.
Correct.
Second.
Okay, it's been moved that we open Rule 44 for what David just described. All in favor of opening 44 for that purpose, say aye. Aye. All opposed, nay. I think the ayes have it. Okay, so how would your wording be, Dave?
Right up there on the screen. And if somebody's wondering what a constituent executive committee precinct chair is, I tried to explain that. And the reason I took that course is that I wanted to keep the language simple. There's probably other ways to describe that, but if you understand what a constituent precinct chair is, then you got it. The example I would use is I talked about before in Harris County, for example. There's multiple representative districts there, and I think it's unfair that people outside the district in Harris County can vote to censure someone that they don't even vote for. Thank you.
Do we have a second to Dave's amendment? We have a second. Any further discussion? Seeing none, all in favor of Dave's amendment, say aye. Aye. All opposed, nay. Nay. The ayes have it.
Mr.
Thank you,
Chairman?
members.
Mr. Chairman, point of information, before we move off this page right here.
What am I
Right here.
hearing?
Sandy Kent,
Sandy,
SDAT.
Sandy, sorry. I'll
Before
come
we
back
move
to you,
off
Chuck.
this, I'm curious, the third line from the bottom, why is recent stricken? I'm wondering if it's a typo, but it's in the. The word recent is stricken. I'm just curious why it is. It's just a point of information. But that's what the hard copy is right now.
Yeah, I didn't do that. That was in the copy
I don't
had.
recall doing that
Neither
as a
do I.
committee. The current rule has recent in there.
Okay, I wasn't sure, and I thought I wanted to ask.
Yeah, I
Sounds
did do
like
that.
it. Sounds like it. There we go. Is that
Thank
back
you.
to the
Thank
way the
you. Yes,
original
I
rule is?
appreciate it.
Yeah, okay. Good catch. Good.
Mr. Chairman. Mr. Chairman.
Okay, now go to Chuck.
Mr. Ch-
We can clean the typos.
Mr. Chairman, Chuck Burnett,
And it
SD20.
changes the meaning, okay. Okay. Sorry. That taken as a friendly, Dave?
Friendly
Do we
amendment,
need to
yes.
re-vote on it, or are y'all good with that as a friendly? Okay, Chuck.
Thank you, Mr. Chairman. Chuck Burnett, SD20. Mr. Chairman, I'd like to see if we could open up Rule 46. This is the one on closed primaries. We've heard much testimony, and I've been stopping the halls over and over about giving certain counties in South Texas an option to opt out of the closed primaries. My people in South Texas are screaming, this is going to hurt us.
Well, wait, before we get to that, let's vote to open it up or not first.
Yes, sir.
Okay, it's been moved. Do we have a second to open up 46? It's been moved and seconded. All in favor, aye. Aye. All opposed, nay. Nay. Oh, that sounded like the nays had it, but I think they're just loud. Let's take a hand count. I know more than that, shout it. Opening 46? Yes, A's first. That's right. Okay, sorry. All the A's, please raise their hand. I had it in my mind, I gotta count them.
Say what?
Okay, I think it's clear that the nays had that vote. Okay, do we have any other amendments? Eric?
Mr. Chairman, since we just refused to open up Rule 46 for that purpose, I move that we open up Rule 46 for the purposes of changing Rule 46 to be one line only. The Republican Party of Texas will conduct a closed primary as authorized by law.
It's been moved and seconded that we strike essentially all of 46. And what was your language? Is that up there?
The Republican Party of Texas will conduct a closed primary as authorized by law. The purpose for this is...
Well, wait, well, it's already open, so you can go ahead and speak to it while they're typing.
Okay. So the purpose for this is when you want to take something to court, you don't want to get thrown out for stupid reasons unrelated for the issue that you want to try.
Point of order, we didn't vote to open 46 yet, again.
Not for that purpose.
Not for that specific purpose. That's correct. In fact, we voted it down for that specific purpose.
Mr. Chairman,
Let's vote to open it up again or not, just to be clear. So Eric's got a motion to open up 46 for the purpose of what he was just starting to describe, to substitute an amendment by substitution.
We adopt a closed primary.
And so, and do we have a second to that? Second. We have a second. All in favor of doing that, say aye. Aye. All opposed, nay. Nay. I think the nays have it again. Do we need to count again? Show of hands. Okay, let's have a show of hands. All in favor of opening up 46 for what Eric proposes, raise their hand. The ayes have, the nays have it. The nays have it. Do we have any other amendments? We've got about 5 minutes. We're not required to take that extra 5 minutes. Yes, sir, Mark, with my initials, Mark.
Yeah. It works well, okay. I had submitted language for a proposed amendment for the end of 44.
For the end of 44, could you briefly describe it?
Yes, at the end of 44, we end with a sentence that says that any CEC county convention, senatorial convention, or SRAC may originate a censure resolution against the Speaker of the Texas House. I propose to add a sentence following that simply states, the SRAC may hold Republican state representatives who subsequently vote to elect a censored representative to be Speaker of the House to be in contempt of the SRAC. And I would speak to why I'm presenting that.
Okay, you've heard the reason for reopening 44. All in favor of reopening 44 for that? Oh, we need a second. Yep, do we have a second? Got seconds. All in favor of reopening 44 for that purpose, say aye. Aye. All opposed, nay. Nay. The nays have it again. I think y'all are getting tired. Yes, David.
Mr. Chair, David Westbrook, SD19. I would like to reopen Rule 11B for the purposes of adding or alternate after the word delegate.
Did you say 11B?
Yes, sir, 11B. It's in the last sentence.
Wait, y'all, do you not want to adjourn? Eric?
It's in the,
It's the
Okay,
next to
and
last line.
could you repeat for what the reason for the members?
So the reason is we had testimony from a couple of delegates about this. There is a loophole in this rule. Currently, if a chair is sanctioned for mucking about, they are prevented from becoming a delegate, but not an alternate by the rule. So if we just add or delegate to the, or alternate to the end, we close that loophole, and they cannot become an alternate and then immediately become a delegate when they get to seat.
On that next to the last sentence, correct?
Yes, sir.
Okay, and we've got a second. All in favor signify by saying aye. Aye. Any opposed, nay? No. I think the ayes had it that time. Okay.
Mr. Chairman.
Yes, Eric.
I move that we open Rule 32 for the
Oh, wait a
limited
minute,
We have to vote on it
We
now,
just
please.
opened 11, so.
Okay.
So David, let's
Well,
have.
let's close that one first.
Let's go ahead and get this one disposed of. Yeah. The delegate or alternate. Is that reflected, David?
That is correct.
Second. Okay, so that's your motion. We've got a second. All in favor, say aye. Aye. All opposed, nay. Passes unanimously, since it was David's amendment.
That is so unfair.
Yes, Eric.
Mr. Chairman, I move that we reopen Rule 32 to propose the following, that we adopt the 2022 language for Rule 32 and add a subsection D that says, no list provided under this rule shall include a delegate's phone number. This will solve the problems with incumbents having lists, non-incumbents not having lists, and solve the problem that people won't get the mass text because we're not going to be passing out the phone numbers.
Okay, so we would, if I understood that right, we would basically be putting
Readopting.
it back to 2022 rule, but not providing phone numbers.
Correct.
Okay, that's the purpose of opening 32. You've heard the reason. All in favor of reopening 32 to put it back? Second. Oh, we need a second. We've got a second. All in favor, say aye. Aye. All opposed, nay. Nay. I think the nays had it that time. Hand count. We've had a request for hand count. We've got about 30 seconds left. Okay, all in favor of reopening 32 for that purpose?
There you go. What am I voting for?
All those against reopening 32, say or raise your hand.
I'm against it.
Can I clarify?
Some of you are not voting.
Point of information. Point of information. Can we?
Not in the middle of a vote,
Okay,
sorry. The nays have it.
Mr. Chairman,
Yes, sir.
I move that the Permanent Rules Committee for the Republican Party of Texas adjourn.
Second. Can we take a cleanup vote first without opposition?
No opposition.
The motion would be that we adopt the rules that were sent to us by the temporary committee with the amendments we've made on the permanent committee for bringing before the convention tomorrow. Do I hear such a motion?
Rick, so moved.
Seconded, it's been moved and seconded. All in favor, say aye. Aye. Any opposed, nay?
Mr. Chairman,
The ayes have it.
Move to adjourn,
Mr.
sign to
Chairman,
die.
point of information, SD17, are we going to get a copy of the new changes that we?
As fast as we can get them merged in. There's one, I think, that was offline that we've got to
Red
merge
lines?
into. Sorry?
With the red lines, with the changes that were made?
It won't all be redlined yet. That'll probably come in 2 or 3 hours, something like that.
Thank you.
Thank you. We are adjourned. Thank you, members, very, very much.